Hi, this is attorney Bill Edgar, and we are facing some unprecedented times here in family law. As many of you may know, the courts are closed. Riverside is closed until April 3rd at least. They are accepting domestic violence restraining order filings and also emergency ex partes. I've been told that those emergencies will probably not be granted and set for a hearing at some point. San Bernardino, I understand, is not accepting any filings right now, but they'll be dropped and then processed later. We are receiving calls, and we are open, but without access to the courts, it's very difficult to proceed with court. But my office is open, and we are dealing with these issues as they come up. And so these are the issues that I have seen with this unprecedented COVID-19 and the lockdown that the governor has recently ordered. The first question I have is, many have asked if this is a school break. My answer would be this is not a school break technically, and regular timeshare will have to be followed. This is clearly a time when parents have to put their co-parenting skills to use. All of our kids are out of school, and that brings up issues of childcare. If the other parent's available for childcare and you don't have to pay for it, use them, communicate with them. There is nothing wrong with coming up with a solution between yourselves that works for your individual family. The court order is still in place. However, if you can't come to an agreement, you can still comply with the court-ordered visitation. You can travel outside to pick up your children and participate in the child custody exchange. Again, these are completely new issues that we are dealing with, and we have not received any good guidance from any courts. You can still go to the grocery store or the park. Clearly, a custody exchange would be allowed. If there is no exposure on either side of the family, follow the existing court order. If your child has a compromised immune system, or let's say chronic asthma, as a caller asked me the other day, then there is clearly a potential problem. Do you send your child for visitation? They call and ask my office. Clearly, I can't seek guidance from the court or go to the court. This is a very difficult question for an attorney to answer, because what you're asking is, can I violate the court order if there is a risk to my child having exposure to this virus? You have to do what's in the best interest of your child. That is done on a case-by-case basis. You need to communicate well with the other parent. If the decision is made not to send a child based on a pre-existing condition, then I suggest offering makeup time, liberal FaceTime, liberal video chat. An attorney can advise you to violate this court order, and so we're in a difficult position as well. But clearly, protecting your children from this disease is important. It's my understanding from what I've seen on the television and read, children are contracting COVID-19, but they are non-symptomatic. That means they have it, but usually they're spreaders. So they're spreaders to the grandparents that we have to be careful of. If you do change anything regarding custody and visitation, it is always best to put that in writing. If you communicate via talking parents, state your agreement. Put it in a text message. Put it in an email message. Most lawyers are working, and we can assist you with reaching an agreement with the other side or the other attorney's side. We're all in this together. We're all going through this together. You can contact me at 951-684-6885 or edgarfamilylaw.com.